Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I'll be your host as we explore this dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us today have the opportunity to interact with our speakers and ask questions. If you want to know anything from Amy and David, please type your question in the comment section below, and we'll make sure to address it. If you're not able to join us, if you have somebody you want to share this podcast with, episodes are released each Monday following the live broadcast. So please feel free to share, like, subscribe, click the alerts icon, and make sure you don't miss an episode. Today, we have my dear friends and KTI colleagues, Amy Gibson and David Wiley, with us to talk about difficult judges and venues and using the edge where sometimes it might not be welcome. Amy and David practice primarily employment law, possibly exclusively employment law, actually, and they are out of Dallas, Texas. We will put their contact information in the description below so that you can reach out with any questions you have about how to handle ornery judges, weird rulings, or difficult juries. These two have learned how to tell their client's story in such a way that they are able to reach even the most staunchly anti-plaintiff, pro-tort reform jurors. Amy and David, please share with us how you dominate in these cases with difficult judges in challenging venues.
Thanks, Jenna.
Thanks, Jenna. But first, let me give a little background. I teach employment for the Keenan Trial Institute. Amy teaches trial, witness prep, and mediation settlement. We're both Keenan Trial Institute graduates and master graduates, and Amy is on the KTI management committee. I think we were asked about how to do this sort of thing, Jenna, because we're in Texas, baby, and Texas has a reputation as being a pretty conservative venue. We say there are some judges who even the Supreme Court of the U.S., like justices like Thomas and Alito, have said, whoa, you've gone too far there, right? And we've had some trial judges here had parts of their dockets taken away by appellate courts. I recall Don Keenan once said, if they ever decide to move the Statue of Liberty, it ain't going to be to Dallas, Texas. And just to give you a little more flavor of where we practice, some of y'all may have heard of the Congressman Louis Gohmert, kind of known nationally. Before he was a congressman, he was a state trial judge for about 10 years, just down the road from us in Tyler, Texas. And now, Texas is a big place, but if you're familiar with Mr. Gohmert, that may give you some of the flavor of Texas. And so this is all by way of saying this. As we were training and learning Don Keenan's trial advocacy methods, something we heard a lot from people and around the country, was this kind of pushback. You don't know our judges, you don't know our juries, we can't do that here. And in response, I like to ask, you think you have a more difficult place than Texas? We had just a couple of years ago, we tried and won an employment case in Abilene, Texas, a town out in West Texas. It was against the city of Abilene itself. It's in Taylor County. The demographics are about 60% white, 25% Hispanic, Latino, about 8% Black. I think at the time, Senator Ted Cruz had just beaten Beto O'Rourke for a Senate seat with about 80% of the vote. So pretty conservative place. We were told by attorneys locally that juries just don't care about plaintiffs' cases out that way. Some had even packed up and moved away. Others tried to file their cases elsewhere. In the type of claim we brought under the applicable statute, it was possible for us to file in Austin, Texas. And if you read a little bit about Texas or live here, Austin is known as sort of a blue liberal island surrounded in a red sea of conservatism, right? The joke used to be that Austin's known as the People's Republic of Austin. But we filed and prosecuted the case in Abilene. And we won, and we were later told that ours was the second highest jury verdict ever in that county in any kind of case. And so I say all that by taking issue with the common thing we've heard about, you don't know our judges, you don't know our juries, we can't do this sort of thing. Now, I noticed in the promotion of this podcast, it mentioned that we take challenging cases that most lawyers wouldn't even bother accepting. And Amy, talk to us a little bit about that.
Thanks, Jenna.
I feel like the spirits in that way because that's young G and I over here. We are like the trash bin for cases, and then we turn them into these like little crystals. So I really love that you guys do that as well.
So that doesn't mean send us your shitty cases, but I think what it means is the cases we take are cases that are actually really good cases that most people wouldn't recognize as good cases. So for example, there are some employment attorneys who will only take employment cases for executives or people who earned or have wage losses over $250,000. We don't decide cases based on wage loss. And I would say same for personal injury attorneys. I hear, the common wisdom a lot of times is, well, this is a broken ankle case, and so it's not worth very much, and it's only worth X. Jenna, you know a little bit about foot injury cases and how to maximize recovery in those.
Yeah, absolutely.
But so we'll take cases with little to no wage or benefit losses. For example, maybe a client has no wage loss, but got shipped off to Siberia to rot and was stripped of doing everything she loved, stripped of her passion, stripped of her job duties. But mostly we try to take cases that make the community better for everyone. So if there's one thing I wish people would get from KTI is to stop assessing cases the old way. Stop thinking a broken hip case is worth X, a broken ankle case is worth so much. Or in employment, it's often thought, well, a really good settlement is a year's wages and a little bit of attorney's fees. No. We all know what KTI helps so much with, as far as showing this to the jury, is that the non-calculator losses are the biggest harm in the case. The harm to dignity, what you're left with after the injury, the emotional harm, not the wage losses.
Yeah, so let's talk about our topic, bad venues, right? One of many things we've learned from Don Keenan is the bottom line here. There are no bad venues. Don Keenan puts it bluntly in an article titled that. There are no bad venues, only bad lawyers who believe the myth of the bad venue. And he even cites the Defense Research Institute, which tags itself as the voice of the defense bar. And DRI has researched the issue and told its own members, venue doesn't matter. That DRI says a mega verdict can happen just as easily in a traditionally conservative venue if the claim is catastrophic and the plaintiff's counsel is top tier. And so, as Don says, venue is overrated. Not only that, it can end up being a self-fulfilling prophecy. You think it's a bad venue, you try your case accordingly, and turns out it's a bad venue for you, right? It's circular. So Amy, could you talk to us about self-fulfilling prophecies and like the common wisdom on venue?
Yeah, and I would say this is true frequently, and KTI reminds us about this all the time. Beware of the so-called common wisdom. Like this venue's bad. Some examples in Texas, there are areas where the common wisdom is jurors think that if something bad happens to you, it's just God's will. Or there are venues where the common wisdom is no damages because up there suffering just makes you stronger. makes you a better person. And it's true, really, not just venue, but across everything. Like, people tell you you can't use the golden rule in certain situations, but black letter law says you can. So be careful about that. And I even catch myself doing it some today. Like recently, it's something about 30B6 depots. I thought for sure I couldn't subpoena the 30B6 to federal court, and I'm still looking at it, but that might not be right. But same with venue, or we often hear juries just don't care anymore. I mean, they just don't care about anyone anymore. But I think a lot of what is happening is attorneys are not adapting as juries change. The case that won a huge verdict 15 years ago is not the case you try to a large verdict today. And by large verdict, I don't mean like raw dollars. I mean maximizing the value for your client, letting the jury understand and appropriately value the harm. But KTI helps with that. Don Keenan, I don't know how many focus groups they do every week, but things are constantly evolving and we have to adapt to them. But as far as venue, let me just give you some examples. In a race discrimination case where 9 of the 10 plaintiffs were Black employees, men, in a jurisdiction that it's not the same jurisdiction, but it's close to a jurisdiction that there are podcasts now about on issues with school boards and people saying, you can't teach, you can't punish microaggressions. There's all this racial tension back and forth in that area. No wage claims in the case, no wages were sought, $70 million verdict. The jury had one Black female on it, and the rest of the jurors were white. The common wisdom was, for a long time, you cannot win a race discrimination case in that venue if your plaintiff is Black. Another example, out of Texas, someone in what was traditionally considered a defense-oriented venue, 1.3+ million in a slip and fall case. Another example, out in West Texas, employment case, minimal wage loss, no physical injury, no counseling or treatment for emotional harm, 2.5 million or so, 2 million of which was emotional harm. In a venue where they said people didn't care, don't believe in mental anguish.
Yeah, and we have some, Texas is such a big state. And even when rules change, I remember the common wisdom used to be that lawyers in Texas would go get an injured plaintiff treated down in the Rio Grande Valley near the border of Mexico to try to get venue there. So, they're injured in North Texas, they go get treatment down there to try to get venue there. And our legislature, I guess, got wind of it and they changed the rules so you couldn't do that sort of thing. But we still think our preference is to have the local community decide local issues. And keep in mind, Texas is, you have coastline and beaches, you have hills, you have desert, you have some of the biggest national forests in the country. It's such a big place. And applying these methods, we just find what Dawn has taught us is true. And that's that venue doesn't matter. So go ahead.
So for our practice, we used to look pretty heavily at venue and where we could file suit and make it stick. And I feel like defense always thought that we were down there in a cave somewhere, all these plaintiffs' lawyers with candlelight, with big venue maps out, and we're circling on them and strategizing. And we were beating a lot of defense venue motions, but our the venue motions we face now have dwindled to zero since we started KTI, because we're just going with where it happens, trusting that the local community is the best to decide what's going to happen in their community.
Yeah, and that's even when we have a lot of choices in employment cases, with both state and federal claims, with things like Title VII of the Civil Rights Act lets you file in any federal district in the state. And we have 4 federal districts here. And so even with lots of venue choices, we still tend to prefer the local community where the bad thing happened. And also because we want the defendant to have to answer to their local community on where they're doing business. So, Amy, let's talk about juries, right? The other thing here is, what do you do about difficult judges? What do you do about difficult venues? What about juries? So Dawn teaches us, find out what they need, right? Find out what they want. Dawn cites us to one of the best-selling books ever, Dale Carnegie's How to Win Friends and Influence People. And the gist is listen to people, give people what they want. The key here is focus groups. Dawn, through his Keenan Trial Institute EDGE methods, teaches us how to focus group and how focus groups are going to help us with overcoming some issues. So, Amy, can you lead us in some examples on that?
Yeah, but before I do, and I should have said this at the beginning, everything we are talking about applies equally to personal injury cases, Section 1983 civil rights cases, consumer cases, employment cases. Same concepts apply. But as far as some ways we have, if you think you have a difficult venue, do your focus groups. I kind of hear Don Keenan in my head saying, for the love of God, attorneys, would you just shut up and listen, for God's sake? Some of the things we have found out in pretty conservative venues where people said juries didn't care is they hate mental anguish, or they think they hate mental anguish, but they are all about anguish over attacks on your integrity, attacks on the employee's dignity, attacks on their ethics, attacks on the plaintiff's good name. And so it just gives you a framework for how to present the black letter law damages in terms of what they care about, assuming you've got those facts. Another example is, I was surprised that a lot of people in a conservative area didn't care that much, or as much as I thought they would, about the physical safety aspects of the case. But they did care about how much the government defendant was wasting taxpayer money. Woo, they cared about taxpayer money, wasting it. Is it being spent to do bad things? And so in that case, we focused on both. The number of things that our client blew the whistle on some unsafe practices. And we also got the evidence to show how many millions in taxpayer dollars were being wasted with those projects. Something else I would say that's gone up for us anyway in focus groups since COVID is treating people with dignity, especially lower wage workers, has gone up, seems to have gone up in importance for focus groups. But yeah, those are just some tiny examples of find out what they care about, find out what they want. I would say for the most part, there are not a whole lot of differences between jurisdictions when it comes to focus groups, but sometimes you'll find that a local area or part of a local area cares more about something that maybe hadn't occurred to you.
Yeah, and some of these things can kind of cross political spectrums, right? When you're really doing focus groups and listening to what people want, sometimes you'll see some allies from across the spectrum who are very big on, one thing, right? Or a few things. And so you can overcome sort of traditional thinking of conservative versus liberal jurors sometimes that way. But again, focus groups are key there. But Amy, let's talk about judges, right? That's what people want to hear about is their judges, right? You can't do this in my court. You can't do this in my jurisdiction. My judge would never, ever, ever, ever let me do this. So what do you think?
I hate to say this, but it is actually rare to have a truly difficult judge. Most of the time when people blame the judge, what we're really saying is, oh shit, I did not see that adverse ruling coming, or I'm not ready for it, or we did something wrong. There have been 2 times in my entire career that I really felt like a judge was being unfair or out to get me. Both of those judges I don't think they're judges anymore. That's how long ago it was. So I would say also with adverse rulings, most often in hindsight, I think that a ruling that went against us ends up being a gift, especially if you win, right? I mean, it takes away various appeal points, or sometimes you get back and realize that in the middle of trial, there's some case that came out and you see it and you're like, oh shit, that came out during trial. Maybe it's a gift. But so, yeah, I mean, I think it's pretty rare, and we'll address how to address the truly difficult judges. But I think for the most part, the POV point of view for the judge is they want to get it right. The judge wants to be fair. The judge does not want to be caught off guard, does not want to be embarrassed, does not want to be surprised in the middle of trial and have to do something without enough time to think about it. And they don't want to look bad, just like us. Like, for example, when you go to trial, they haven't been living with the case. They don't know that your opposing counsel, squawks over nothing when there's nothing there, or that they don't tell the truth. And so when defense says, judge, we can't possibly win this case if that evidence comes in, oh, the prejudice. And we're saying, judge, how can we try the case without it? It is all over the documents. It's all over the testimony. Well, the judge does not know at that point who is telling them the truth. A lot of times, initial rulings are not necessarily going your way, but then once you get into the trial, at that point, the judge starts ruling in your favor, because then they can see that you were right. You were telling the truth. But definitely do your homework on the judge. Like, some judges have a lot of trial experience. Some judges have little to no trial experience. Some judge may have practiced in the area of your case, and some judges practice in a different area. Even those basic things, just like jurors, if they know about it already, you don't want to insult them by giving them the ABCs. But if it's something they don't know about, do what we do with juries. Be a good teacher and give them the tools that they need so that they look good and they feel good about whatever decision they make. So, for example, in Texas, sometimes a defense attorney will say, objection, failure to fully open. People who try cases know what that means. It means you didn't address a required part on damages in your opening. But if the judge doesn't have trial experience and the defendant objects failure to fully open, the judge isn't probably going to know what that means. For judges who don't have a whole lot of trial experience, some things we find we need to brief is when you can lead your own witnesses. It's in the rule. It's right there in the rule, but they're not probably going to know it. authenticating a document with circumstantial evidence instead of like more traditional ways. A lot of times judges without trial experience don't know that. I mean, just think about some of the common things in addition to what KTI teaches you in black letter law that you might want to have a very short brief for the judge early so that they can feel good and do well and look smart. Help the judge look smart. I mean, sorry, judges, you are smart, but I mean, even in an area they don't know that well. And then some things that have worked for us, not necessarily at trial, but before trial, through trial. Judges care very much about whether the parties have a good experience with the judicial system. We'll talk about how that plays in a minute. They understand that you have fiduciary obligations to your client, which may require you to raise arguments at certain times. And when it comes to trial, the easiest thing we have found is using what the other side is saying to get our evidence in. 90% of the evidence we get in is because the other side has said something or offered a document or said our client only cares about money. Judge, we get to defend that. They've just said this is all about money. That way the judge doesn't have to like read the cases or read the case the defendant came up with after 5 years of litigation. Oh, judge, we just found this case from 1924 after 5 years that we think is totally, on point. I just think that's has been easiest for us.
Yeah. And so my point on that with judges too is so often we hear lawyers gripe about difficult judges, and I think there can be difficult judges, but sometimes if you really drill down, it's the rulings you're thinking are difficult, not necessarily the judge. And there may be some ways to sort of get the judge's point of view and work around what we think are difficulties. Not only that, but sort of turn them in our favor, right?
Yeah. And one thing that Don Keenan has done in sharing how to pick a jury, how to try a case, what to do in case intake is he is taking average attorneys like us and putting them on the map. And I think one thing that helps with judges, you do good briefing and all of that all the way up to trial, but you try a great case, you are well within bounds, you are well within black letter law, and it's enjoyable. It's enjoyable for the jury. It's enjoyable for them. And so I think that helps too. I mean, I've seen people who obviously read a book or something, and so they're trying a little bit and I just want to cry for them. It's horrible. And it usually happens when I'm going to watch an attorney and that case is settled and I don't realize it until someone gets up and I don't want to leave, before the next break.
Yeah, and the difference between difficult judges and difficult rulings, one of the many things I like about these KTI Edge methods is that you get to practice these methods in a controlled environment through the KTI colleges, for example. You get to learn and understand why these methods work, and then you'll learn how easy it is to adapt if a judge is giving you a bad ruling or a ruling you don't like, and how you can, look at things from their point of view, look at what they need, and, pretty easily adapt to give them what they want and skirt the notion of just, well, this is a difficult judge and I'm never getting this stuff in. Amy, I mentioned point of view. Can you talk to us about point of view for us?
So when David and I were talking about this, and definitely taking each other's constructive criticism really, really well. I mean, no spats whatsoever. We did agree on this. We think kind of the root cause of people's thinking bad venue, difficult judge comes down to us our POV, what's going on in us. And what is it, David?
It's fear, right?
Right.
It's fear. It's our fear.
It's fear. And, we heard a lot from other attorneys when we might say, hey, does anyone have an order from this judge allowing you out of court ordered mediation? And we get all these private emails. Oh, you don't want to do that. Oh, don't ask to get let out of mediation. Oh, you're going to piss off the judge. No, the judge didn't care.
Yeah. And it's listening to the common wisdom again, sort of like venue with our POV. When people get scared of judges or scared of things, it's maybe because it's self-fulfilling prophecies, listening to the common wisdom. I think we've got to overcome that fear and don't be afraid to ask for what we want and be bold. Amy and I had a partner, maybe 15 years ago, who was a Marine in Vietnam. And he and I were preparing for a non-compete injunction hearing. And his name was Don. And I said, Don, I don't think the judge is going to like this one argument. It might contradict some things. And I just worry that, about making this one piece of this argument to this judge. And he was kind of an older, Texas trial lawyer, right? And he said, I'll never forget this. He said, David, what do you think that federal judge is going to do to me? You think he's going to shave my head and send me to Vietnam again? I thought, well, no, Don, I guess not. And he said, a federal judge, and I always think of that when I think, golly, this judge is being difficult, and can I do this in court or something? And that's, be bold, be brave, practice what you're going to do. And sometimes it actually really works out pretty well when you're not following the common wisdom or what you've heard about a particular judge. And Amy, can you put some meat on the bones here? Give us some examples of things where people are like, oh, don't do this because that judge, blah, blah, blah. And then you go do it and it works out pretty well.
Yeah. And although no judge has ever threatened me with contempt, Don always says, oh, come on, tell me the last attorney who died of contempt. I mean, seriously. And if he said, if you did, at least you'd be known for something. So, but I would say, number one, do not be afraid to ask for what you want or what you need. A big area I see this, I will see attorneys ask for less jury selection time than they think they need because they think that's what the judge wants. I would say ask for as much time as you think you need for jury selection. The worst that'll happen is the judge says no. I may not get everything I ask for, but I usually get more than I would if I didn't ask. And sometimes you might even say, Your Honor, if you think I'm doing it wrong, if you think I'm out of bounds, if you think I'm doing anything inappropriate, please cut me off at any time. Tell me to stop. But then they'll see that everything you're doing is within the law. It's black letter law. It's good because you learned it at KTI. And it often ends up being enjoyable for them. But even before trial, some examples are whether you're in state court or federal court, if you have kind of a scheduling order or scheduling conference, ask for what you want, ask for what you need. A fairly new federal judge, we had a conference in front of him. The defendants, you know how they have 55 affirmative defenses. Some aren't even applicable to the case. It wasn't that many, but they had so many stock defenses that it was going to burn all of our interrogatories if we sent them on those. And without debating whether that's the right way to handle it or not, I asked for additional interrogatories in the amount of their defenses. And the judge said yes. And then the defense attorney said, well, to be fair, we want that many more too. And he's like, no. This is purely because you've got, and really, as he glanced at their defenses, it's pretty clear that they were mostly BS defenses. If you're in a jurisdiction that has limited time to respond to dispositive motions, ask for more time. We will routinely ask for at least 30 days to respond to dispositive motions because in Texas, a lot of times the time is shorter. I think it's a bizarre world when people have more time to respond to document requests than to something that could be a case ender. We'll ask that think all the way through the process. Like we will think it through to trial and what the pretrial rules are. We will ask, for example, that we not have to include demonstratives in our exhibit list. Usually defense will agree on that. A lot of pretrial rules require that each side object to the other side's exhibits in a use it or lose it fashion. Like if you don't object, you waive it. We've been able to convince judges to not require the parties to do that. What we explain is that just forces the defense to object to make every possible objection in the world. And you don't really use all those objections at trial. And it's just easier for everybody to decide whether and what to object on when we see the context and what the evidence is. And don't be afraid to ask that mediation be voluntary rather than court ordered. We do that regularly. Sometimes defense agrees with us. Sometimes they're like, oh, I'm not going to be the one to say that. And fine, we will argue it. And even when we don't win something, a lot of times the judge will give you a path forward or say, okay, I'm going to go ahead and order you right now, but Ms. Gibson, Mr. Wiley, if you feel like it's really going to be a problem as it's coming up closer, you go ahead and file something and I may go ahead and let you out.
Yeah, and that's where we see a lot of chicken littleism too, right? Where defense counsel say, oh no, this judge always orders us to mediation. We don't want to vary the scheduling order. And we'll talk to other plaintiffs lawyers in the area and they might say, oh yeah, no, that judge always does that. You don't want to do that. And, we've sort of found the opposite, that when we go in and ask what we want, even on judges who have their own little detailed scheduling order, if we go in and ask for variations, actually a lot of them kind of find it refreshing or interesting because no one does, right? And so we'll say, Judge, here's why we'd rather mediation be voluntary rather than by court order. Or here's why we want all of these other additional things, or here's why we don't want these kinds of deadlines. For example, Amy mentioned some expert deadlines. I use the analogy that, you give a little boy a hammer and he's going to find something that needs hammering, right? And so you give a deadline for an expert challenge. Guess what's going to be filed by that deadline is an expert challenge. And maybe we'd rather just see if they raise the challenge at trial and be just ready to handle things at trial, right? The old-fashioned way. So there are, a number of things where just don't be afraid to ask the judge just because the common wisdom is not to do so.
And then another thing is don't be afraid to ask for anything from a judge if it will give your client a better experience with the judicial system. I remember having a conference with a magistrate judge in federal court, and it was about mediation. He wanted to know why I was so against court-ordered mediation. So I explained it in the context of this is our client's first and hopefully only experience with the justice system. Mediation is a huge part of what they think about the justice system. Let me explain to you what happens when we are forced to mediate and the other side is not serious. And I talked about icing our clients, leaving them alone in a room after they had to take off work which is hard for a lot of our clients. I mean, it's certainly not easy. We talked about icing. We talked about the other side literally saying, you are not going to get justice here. Or just acting like we control everything. We're going to get what we want. We get to control this program, including mediation. We talk about the other side's money person having to catch a flight early, but our client has to stay. Or they don't show up with the person they are supposed to. And so that person doesn't have to be there, but our client does. And, this particular judge was very interested in that because nobody else is speaking up about it, right, about what is really going on. Other times, even for, I know we're talking about judges, but even for mediators, a lot of times mediators will bark at me the first time I do something, but what I'm doing is for the client, and I'll get, you do not run the show here. Amy, you don't run the show. Oh, you are absolutely right. I am not running mediation, but I am the only person in this room that owes my client fiduciary duty. Oh, I'm not going to interfere with that. And then some of the things you find out later, like one mediator who is in private practice, he told us at a later mediation, he said, oh, by the way, I started adopting some of the things you were doing because they work and it's a better experience for the client.
Yeah. And let's talk about adapting. You have what you think is a difficult judge. Maybe it's really just difficult rulings, but not as difficult to judge as you think. And you want to adapt to those rulings. So let's talk about some examples of how we've adapted to difficult venues, difficult judges, difficult rulings, that sort of thing. Rarely does one ruling really gut our entire case if we know how to adapt. Sometimes, but one of the things I like about the KTI Edge methods are that they're like a set of tools, right? And if one's not working, you've got others. I initially learned jury selection from KTI instructor Len Gabay, and he analogized to, it's like a Batman's utility belt. You've got all these tools you can use. And so if a judge shuts you down with one, you've got another one you can use. Let me put it right in your own kitchen, right? So if you have the knife you really want to use is dirty, or someone's taken it away, or it's dull, do you just give up and order in? Or, can you use a different knife? Can you use, if your chef's knife doesn't work, can you use a paring knife, right? If you don't have a bread knife, do you have some other serrated knife? If your cereal bowl is dirty or taken away, do you have another bowl you can use? But basically, these are all sort of tools. And when you really start mastering them, it's fairly easy to adapt rather than just say, oh, this judge is terrible. And, that's my whole case, Chicken Little. So, Amy, can you share with us some ways we've adapted to some rulings?
Yeah, sure. And just keep this in mind. There's a lot of just false information out there about what Don Keenan teaches, but he's teaching you how to be a better attorney from learning how to do a focus group correctly. What do you consider on case intake? What the heck are you actually looking for in jury selection? Okay, I can strike that person, but really should I? Just taking everything to a deeper level. So if some rulings go against you, it would take a tsunami to wipe out everything you are taught. You can still win, even having to overcome some hurdles. But I would say, for example, one thing we're doing is on our safety rules board, we're going to have an extra piece of Velcro and a board that says the evidence will show, because a lot of judges just want that lingo. But if you can't use it, so what? Use it in some other part of your case. It is not the end of the world. use low-hanging fruit, like somebody wanted to exclude issues concerning training or the need to train. But in our cases, and look this up, no matter what kind of case you have, can you get injunctive relief? We will ask for injunctive relief, not like a temporary injunction. We're talking end of case decision on injunctive relief, equitable relief that would get to the root cause of what is causing the bad thing to happen. And so we had pleaded training and basically said, Judge, you're going to have to decide this. Do you want to have 2 trials or 1? And so that made it easy. Also, I would say, don't be afraid to ask questions. Sometimes it's not a ruling, but a procedure. So for example, a judge, if one judge doesn't have the jury take their notes back with them to the jury room, like they can take notes throughout trial, but they can't take their notes with them to the jury room. So I just said, Judge, is it okay if I let them know about that procedure, that's your procedure? And then I said, and here's what I'd like to say. And I ran it past him. And I think I said something like, I'm going to let them know that if there's anything they want, they're afraid they'll forget, there is going to be paper and pen in the jury room and they can write down what I say real quick. And he's like, well, Ms. Gibson, how about what either side says? Oh yeah. Good point. Good point. Yes. And so I got his blessing on addressing his procedure and how I was going to phrase it and what I was going to say. I've also had a judge, and this turned out to probably be a gift, but he gutted a big piece of our damages that we were seeking to recover. It gutted my closing argument. I asked him if I could have overnight to rework it. He said, how about a couple hours? I said, I really feel like my fiduciary duty requires me to ask for overnight. And he actually asked the jury if they'd rather do close in the morning or maybe stay a little bit late that day and go ahead and close. And they said they'd rather come back in the morning. So I did get overnight, but I actually thought that was genius of the judge. Like, I'll just leave it to the jury. What else? And also, don't be afraid that you're going to look dumb. If you need to ask a question, ask a question. I learned 2 different names for how different ways we do an offer of proof in state court in Texas. Defense counsel used a phrase that I had not heard. Thankfully, Brian Sanford was standing right beside me. And I just said, Brian, what kind of offer of proof is that? In front of everybody. The jury's not there, but opposing counsel is there. The judge is there. They are snickering. He tells me and we do it right. I mean, so what? Who cares? So don't be afraid of that.
Amy, Jenna had asked us to address something about, motions in limine about reptile, even long after the reptile funeral, that what do you do when judges grant the anti-reptile motion in limine, or when they say, you can't say safety, or you can't say rules, or safety rules aren't in employment cases? And what do you do?
You adapt, although, well, the first thing you do when you get the MIL is go to your state listservs. Okay. Don't try to do it by yourself. Get help, get collaboration. They have the best cases. Some of them are so outdated that probably, it depends on what's in it, but some of them are so outdated that I would say half of it were like, yeah, so what, Judge? We don't do that. What are you talking about? Y'all are about a decade behind on those things. If you can't use a certain word, hello, 20 years of formal education, get out the dictionary, use different words that your focus groups have used. And also, a lot of what we thread and embed throughout the case No, it's subtle, I guess I would say. And so I just can't imagine, even if you couldn't do something. Now, Mr. Keenan is a little bit different because the other side doesn't like that he's teaching people to be really good trial attorneys. And so he kind of has a target on his back. So he has it worse, and David Hoey has it worse, and Tony Seaton has it worse, and Mindy Bish has it worse than we do, because we don't have that target on our back. But you can always adapt. You can always use a different word. If you can't do something one way with one witness, do it a different way with a different witness. But I would go back to 90% of the time, a document they put in evidence, what they said in opening, what their cheerleader witnesses said is going to allow you to do whatever you want to do, even if the initial ruling's against you. Like, judge, they're opening the door. Judge, we need to let the jury out. We need to have another discussion. And several times we've had a judge look at the other side and say, like I'm saying, Judge, they're saying this is no big deal. Like what they did, that it doesn't have any big consequences. And Judge, they're saying, they're so careful. Or they're saying, or they just offered this document that said it's all about the money now with our client. And I remember a judge looking at the other side and saying, there has been a lot of that. There has been a lot of that. I think I'm going to have to let her get into this. That's easy. So, don't give up. Don't give up.
Yeah, the name of the game really is in all of this adaptation. And that's what Dawn and you guys and I teach at KTI is we teach tools, and you have to learn how to use those tools. Sometimes when you really want to use a socket wrench, all you have is like the regular wrench. You can still use it for the same purpose. It might be a little bit more awkward, but it actually might be a better fit, for whatever reason. And so you really want to know the law. And I really like, you guys, what you talked about not listening to collective wisdom. And that doesn't mean that you should vilify it or anything. I mean, it comes from somewhere, right? So have it be like the base, I guess, of whatever it is. But, in Washington, we don't have punitive damages at all. We don't have caps on damages, but we don't have punitive damages. So it gets a little weird with like punishing and that kind of stuff. So I have a case coming up where I really want to get into deterrence. And there's a lot of good black letter law about deterrence here in Washington. But I was like, I have a brief that I was given from the Collective Wisdom Bank, and it's pretty good. I'd give it a 6 out of 10. It's pretty good. Well, I decided I'm going to read the cases, and I'm going to go further down the rabbit hole. And there are several cases where the judges actually use the word punish in deterrence. So they're like, the deterrent effect is to punish the defendant. It's to punish the defendant. And I was like, we have punitive damages. It's just not called that. So, I mean, you guys, there's stuff out there that you got to do the legwork to get in. And then at the end of the day, as David and Amy have been talking through this whole thing, we're the vessel. We are the deliverer of the information. We're the teacher. We got to make that jury and that judge friendly, even if other people have had a different experience. I mean, I just think that's the bottom line. And that's what I've heard from you guys today.
Yeah. And now I haven't had a judge come up and say, oh, I did like you at first, but I love you now. But jurors, we've had people on the jury who initially were like, I would rather sit in jail than sit through this case because defense overreaches and lies in jury selection. Mm-hmm. Ended up saying, I missed my birthday and I was proud to, because this was important. And I'm so proud to be part of this verdict. And like, they just completely changed their tune. Mm-hmm. And so pre-KTI, I probably would have had a lot more trouble mm-hmm. with venue and judges. Mm-hmm. But what Mr. Keenan's teaching helps us be better attorneys. We get better at it, and everybody loves to watch a good trial.
Yep. One where we're not like Is it the judge isn't like, oh gosh, are they allowed to do that? Nope. I read a brief. I saw other judges have decided before me. I feel comfortable about this. Let's proceed, everybody. And then the jury's like, yeah, these people know what they're doing, and everybody feels good except for the black hats.
Yeah, no, they don't. They think they know what we're doing, and that is funny.
Yeah.
But they don't.
And I do want to reiterate with that as well. This is a public podcast and anybody can listen to this, and, who knows, but nobody knows who I am. So nobody cares about it really. But, if those of you who are listening, go to colleges. Both David and Amy are fantastic faculty members. They'll teach you how to do this stuff. This is kind of a taste, an idea, anecdotal discussions and stories about how you can do this, how you can make juries and judges that you were afraid of before not so scary. But go to the colleges and learn how to do it. This isn't going to be enough for you to hear just stories about how it's done. And if all you do is listen to the podcast or webinars or seminars, you might feel frustrated. And so I want to, if people do feel frustrated out there, like, well, I've tried that, it doesn't work. That's okay. Come to a college and talk to faculty and find out what happened and find out if there was a disconnect. We have a question from the audience. So before I sign off, let's see. Kevin Henratty says, why are we calling it collective wisdom when we are talking about the common knowledge of low-level attorneys?
So by collective wisdom, I have found there are certain things I learned that I repeated because I didn't look. Okay. Like everyone knows X, it's just how, and then suddenly I'm like, oh, well, Amy, have you looked at the law in 20 years since? And it's just something that gets repeated. Personally, sometimes I think, did defense lawyers start that rumor? It got us to somehow adopt it. And I hope that answers your question, but I'm not trying to be mean to anyone. It's just sometimes there are things you hear about a jurisdiction, about how a judge is, about what the law is, about what you can and cannot do in trial. And you realize that what you've heard for the last 30 years is wrong or not complete, not the whole story.
Right.
Once you actually dig in and look at your black letter law.
Yeah, and it can be self-fulfilling prophecies like Don says about, the myth of bad venues, right? It's a bad venue, so you don't do as well as you could have, and then you give up, and then it's a bad venue, right? And so it's circular, and so same sort of thing.
Like I was taught in law school that you cannot use the golden rule at trial. Now, my teacher was a defense lawyer, but that's not true. It's true for certain pieces of damages. It's always true that you don't want to turn your case into, us versus them and just be prejudicial, over the top sympathy or we want a verdict because we want you to hate big companies. You can't do stuff like that. But there are ways in which you can use it. And
in certain
I just assumed my professors were correct. But what they were telling me was, I would say it was probably a half truth. Half truth.
Yeah. Yeah. I ran into a similar situation recently where I looked at the case law on what golden rule was in my jurisdiction. And it actually literally is from the defense or the plaintiff side. The judge gave in this ruling, gave several examples. And it was, if you were in this party's shoes, what would you do? Or what would you want? And that's what it is. I mean, at least in Washington. And I'm not going to do that. And I'm not going to use that word. So really, there's a lot of latitude there, even more than I ever thought. And I will say too, Kevin, sometimes I hear from the top, who we consider the top trial lawyers in our state, repeating some of this stuff. And it's really damaging because things like, oh, we don't have corporate negligence in Washington, or we don't have this or that in Washington really isn't true. It's just the mantra we've all picked up and passed along because somebody with authority, like a law school professor or a seasoned trial attorney with good intentions, certainly not to harm anybody,
Right.
made a mistake, misunderstood something, maybe heard it from somebody else and passed it along. So really the moral of the story is to kind of just do your own legwork. Don't, even if somebody hands you a beautifully written brief, make sure I've done that. I've given someone else's brief to the court and then the court asks me what this case says. And I'm like, oh, I don't know because I didn't read it. Oh yeah, Your Honor, it says what it says in the brief,
Yeah, Jenna, I think some healthy skepticism and questioning authority there, particularly if you are a newer attorney. I think newer attorneys get gaslit more than those of us with some gray in our hair. And, I used to get that a lot. Oh, a jury's going to think this, a jury's going to think that. And, now that we go in focus group, when someone tells me that still to this day, I'm thinking, well, I already know what a jury's going to think about this. I already know, 5 ways to deal with it. And you're telling me, here's what a jury's going to do. And so, when you hear those things, an employment case is worth a year's salary. An ankle case is worth this much money. Question that stuff. Question. And we're going to go find out.
Or anytime you go to trial, you're rolling the dice. No, you're not.
Yeah.
No, you are not. Not if you are working up your case correctly and picking good cases.
Yeah, and think of all those phrases we hear along those lines, right? A good settlement is when everyone's unhappy, right? I mean, these kinds of phrases that sort of like a parasite sort of glom on to the law and this idea of common wisdom about the law and how everything is done. Question that stuff, test it. Don't guess, don't accept it, test it.
And on all of this, I know, we even had discussions. I was like, David, you can't say that on the podcast.
Yeah.
We can't give away secret stuff, but the colleges help you understand the why of what you're doing that you're not going to find in the books. And once you understand the why, it makes it really easy to adapt. It also makes it really easy to, we want to be subtle, but you can do it all day long in different ways if you understand the why and practice.
Yep, absolutely. The spirit of what is behind what it is that we're doing. That way, I don't even use a rules board anymore because I've gotten so much flack. We have to exchange all exhibits beforehand. And so it just inevitably, an SH something T storm comes down on us. And I'm like, I don't want to deal with that. Okay. So I figured out a way that we still do rules. We still do everything, but nobody really knows. Right. And it's not so obvious and it's not that visual to tip them off ahead of time. And it doesn't start the shitstorm. And it's just, so there, once you know how and why, it's, you can do it. Everybody, you can do it.
And FYI, everyone, you may have to adapt because there is apparently a foam, I can't say it, I'm from Waco, Texas, foam board shortage.
Oh, supply chain issues.
And so people are having to use their old ones from old trials. So order early.
The first thing in Washington that we learned as children, our first phrase is reduce, reuse, recycle. So that is good. Good job, everybody. Okay. Thank you so much, Amy and David. Thank you for being here. And thank you to all of you who joined us today for this week's episode of Fridays with Keenan's Cutting Edge. Remember, at the end of the day, it is up to us to make our judges and venues friendly. It is up to us to defeat that bad ruling about reptile or lizard law or whatever you encounter. And you can do it. If you like today's video, please click that thumbs up to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have Adam Anderson with us. Adam is going to share with us about power words, why they're powerful, how we can use them, why we use them. And I look forward to learning from Adam next week, along with all of you. Have a wonderful weekend, and I'll see you next time.